On June 7, 1892, Homer A. Plessy was proceeded against in the criminal district court for the parish of Orleans. The charge being that, one, Homer Adolph Plessy, being then a passenger on a train belonging to the East Louisiana Railroad Company, and on which the officers said East Louisiana Railroad Company had power and were required to assign and did assign the said Homer Adolph Plessy to the coach for the race to which the said Homer Adolph Plessy belonged, unlawfully did then and there insist on going into a coach to which by race he did not belong, contrary to the form of the statute of the state of Louisiana, in such case made and provided, and against the peace and dignity of the same.
Oyez, oyez, oyez. Order in the court. Counselor Walker, please proceed with your argument.
Your Honor, please. James C. Walker, here on behalf of defendant Homer Plessy, present in the courtroom. Mr. Plessy, please rise and be recognized. Your Honor, we are a mover in this motion in limine to have Your Honor declare the Separate Car Act, Act 3 of 1890, to be unconstitutional. Your Honor, Section 2 of that act gives to the conductor of a railroad train the power to determine the question of a passenger's race and to arrest the passenger in accordance with his sole decision as to that passenger's race. It gives the conductor of a train, Your Honor, an individual with absolutely no legal training or qualifications, judicial functions equal to your own. That train conductor can determine the race of a passenger without hearing aught that the passenger may have to say. If a man is but 1/16 colored, he may claim to be, and for all intents and purposes is, under our law, white. And he can nonetheless be ordered into the colored car by the conductor if the conductor determines that he is not white enough. And the refusal of any passenger to abide by the decision of the conductor is, by this act, made a criminal offense. A criminal offense, Your Honor. Our Louisiana legislature has no power to confer judicial functions upon a conductor of a passenger train, nor to make a peaceable refusal to accept the decision of some railroad employee as to the race to which the passenger belongs, a crime punishable by fine or imprisonment. Section 2 of Act 3 provides a summary punishment without constitutional due process of law. It allows a railroad conductor to summarily refuse to carry a passenger in the whites-only car that the conductor alone determines not to be white or not to be white enough. And to make matters worse, it not only makes it a crime to not abide by the arbitrary determination by the unqualified conductor, it also provides no redress for the passenger, none. Under Section 2 of the Act, both the railroad company and the conductor are exempt for any claim for damages for any incorrect decision by the conductor. To suggest that such an act is constitutional is, with all due respect, preposterous. Even my learned, albeit misguided, opponent, Mr. Adams, concedes and admits that at a minimum, that part of Act 3 violates the Constitution. But it is not just the lack of redress that renders Act 3 unconstitutional. I respectfully suggest, Your Honor, that the stated title of Act 3, to wit, quote, to promote the comfort and safety of railway passengers, is truly not its real intent. Its real intent is to legalize a discrimination between citizens, classes of citizens based solely on race and color. Its intent and its practical effect is to sort and classify passengers upon railroads according to some arbitrary determination of race, and to make the rights and privileges of all citizens traveling within the state dependent upon that classification. As Your Honor well knows, race is a scientific and legal question of great difficulty. The state of Louisiana has no power to authorize anyone, much less a civilian train conductor, whether he is an officer of the railroad or not. He is not an officer of the court, much less a judge, to determine one's race without testimony, without qualification or expertise determined by a proper court of law. And yet, that is exactly what Act 3 of 1890 authorizes. Your Honor, Judge Sawyer of the United States Circuit Court of California declared unconstitutional a San Francisco city ordinance compelling the close cutting of the hair of all prisoners arrested on the grounds that it was race legislation aimed against the Chinese. Act 3 of 1890 is likewise race legislation. Race legislation aimed against the colored men and women and children of the United States of America. It establishes an insidious distinction and discrimination between citizens of the United States based on race. That discrimination is obnoxious to the fundamental principles of national citizenship. It perpetuates involuntary servitude as regards citizens of the colored race under the merest pretext of promoting the comfort of passengers on railway trains. And in further respects, it abridges the privileges and immunities of citizens of the United States and the rights secured by the 13th and 14th Amendments to the Constitution. Your Honor, the great statesman Daniel Webster was frequently mistaken for a colored man. And were he alive and today traveling in this state, could be made to suffer under this Jim Crow bill because of the arbitrary determination of a train conductor. The object of the 14th Amendment, setting forth the doctrine of the equal protection of the law, was and is to prevent class or race legislation on the part of the several states of America. The act in question stamps the colored man with the badge of servitude and with respect must, Your Honor, be declared unconstitutional. Thank you for the court's time and attention. We pray for justice.
Thank you.
Assistant District Attorney Adams, please proceed with your argument.
Good afternoon, Your Honor. Lionel Adams, Assistant District Attorney for the state of Louisiana. May it please the court. Civil rights decisions of the federal courts have established the legal fact that common carriers have the right to separate passengers from each other on race lines. The act in question makes the railroads responsible to the law if they do not provide equal and proper accommodations to the passengers of the two races. You will forgive my learned opponent's hyperbole, but the conductor is made nowhere the judge of a man's race. But he is instructed to see that no passenger rides in a car to which he is not to be admitted on race grounds. Now, you strike out the section of the provision of the act which gives the conductor such powers. Strike it out altogether. And as agent and representative of the road, he is still bound to enforce the rules and laws governing the road. And he is subject to personal responsibility and liable for damages if his judgment errs in the determination of a passenger's race. Under the act in question, a Negro is not deprived of redress, for if the accommodations are not equal, he can claim damages. And under the act, under the Act, the railroad would be liable. However, he has no right, nor has the white passenger, to force his entrance into a car set apart by the law for the passengers of the other race. The true question before the court is not the constitutionality of the act, but whether or not the accused under the act committed an offense under the laws of this state. The act in question gives all passengers of both the Caucasian and African descent equal, but not common rights, which is in accord with the decisions before quoted of federal courts relative to common carriers and hotels. In conclusion, and simply put, if the legislature had the right, under federal court decisions, to separate white and colored passengers, the law is constitutional. Thank you, Your Honor.
Judge John H. Ferguson of the Criminal District Court, sitting en banc yesterday, November 18, 1892, in Section A read the following decision on the motion to quash the Bill of Information against Homer Adolph Plessy, colored, for violation of the Separate Car Act on the East Louisiana Railroad.
Oyez, oyez, oyez. Order in the court. The Honorable Judge John H. Ferguson will now hand down his ruling.
The information in this case is based on Act Number 111, approved July 10, 1890. It charges that the defendant unlawfully insisted upon going into a coach to which by race he did not belong. There is no averment as to the color of the defendant. Defendant, before arraignment, filed a plea herein based on 15 grounds and prayed therein to be dismissed and discharged. The title of the act referred to is to promote the comfort of passengers on railway cars, retaining all railway companies carrying passengers on their trains requiring all railway companies carrying passengers on their trains in this state to provide equal but separate accommodations for white and colored races by providing separate coaches or compartments so as to secure separate accommodations, defining the duties of the officers of such railways, directing them to assign passengers to the coaches or compartments set aside for the use of the race to which such passengers belong, authorizing them to refuse to carry on their train such passengers as may refuse to occupy the coaches or compartments to which he or she is assigned, to exonerate such railway companies from any and all blame or damages that might proceed or result from such a refusal, and to prescribe penalties for all violations of this act, etc. It is urged by defendant's attorney that the title of the act to promote the comfort of railway passengers, etc., is evidently not the design of this act, that its purpose is to legalize a discrimination between the classes of citizens based on race and color. This law is clear and free from all ambiguity, and the letter of it is not to be disregarded under the pretext of pursuing its spirit pursuant to Civil Code Article 18. Judges have nothing to do with the policy of particular acts passed by the legislature. The will of the lawgiver being understood, nothing remains but to carry it into effect. It is claimed also, and in fact it is conceded by the state's attorney, that such part of the statute is exempt from liability. The railway companies and its offices is unconstitutional. It is a rule of interpretation that a law may be unconstitutional in part and valid in all other parts. Eliminate the clause which is objected to, and then remains a perfectly valid and constitutional enactment. It is further argued in support of the plea herein that judicial functions are delegated to the conductor of the train by the legislature, and that it is extended to its authority by so doing. In an analogous case reported in the Federal Reporter number 23, page 319, it was held that the conductor was the proper officer to decide upon her, a colored woman, right to ride in the ladies' car. The act in question authorizes the officers of the train to assign passengers to the coach or compartment used for the race to which such passenger belongs to decide upon the right of defendant to ride in a certain car. The officer, it is true, determines for the time being the question of color. He does so at his peril. His decision is subject to subsequent judicial investigation and determination. Clearly, railway companies have the right to adopt the reasonable rules and regulations for their protection and for the proper conduct of their business, and to designate who shall execute such regulations. It is the nature of a police organization. It is therefore said companies have such right. It follows that the legislature, the lawmaker, has the uncontested right to so declare in an expression of legislative will. Counsel for the defendant contends that the accused is deprived by the said powers delegated to the conductor of liberty and property without due process of law in violation of the Constitution of the United States. It would be impractical, in fact, almost impossible, to organize and utilize a circuit court or any tribunal with special jurisdiction to instanter on the train, try and determine the color of a passenger, whether the question was specifically put at issue. The defendant herein was not, in a proper sense, deprived of his liberty by the act of the officer of the company. There is no pretense that he was not provided with equal accommodation with the white passengers. He was simply deprived of the liberty of doing as he pleased and of violating a penal statute. It is urged that defendant was deprived of his property because he purchased a first-class ticket and never used it by reason of the act of the conductor. The railway company was blameless in this matter. The ticket purchased by the defendant was not used simply because the defendant refused to ride in the car or compartment to which he was assigned by the conductor without a valid reason for said refusal, and insisted on going into a coach in which by race he did not belong, according to the information. Another ground is that said act does not afford an equal protection in violation of Article 14 of the United States Constitution. The act expressly provides that all railway companies carrying passengers in their coaches in this state shall provide equal accommodations for the white and colored races. Also, that any passenger insisting on going into a coach or compartment to which by race he does not belong shall be liable to a fine, etc. According to its provisions, should a white passenger insist on going into a coach or compartment to which by race he does not belong, he would thereby render himself liable to punishment, according to this law. There is, therefore, no distinction or unjust discrimination in this respect on account of color. The important question for consideration in this case is, had the legislature the right to authorize and empower railway companies within the state to provide equal but separate cars or compartments for the colored race? In the case entitled Longwood and His Wife versus Memphis and City Railroad Company, Judge Hammond of the Circuit Court charged the jury that common carriers are required by law not to make any unjust discrimination and must treat all passengers paying the same price alike. Equal accommodation does not mean identical accommodations. Races and nationalities, under some circumstances to be determined on the facts of each case, may be separated. But in all cases, the carrier must furnish substantially the same accommodations to all by providing equal comforts, privileges, and pleasures to every class. Colored people and white people may be so separated if carriers proceed according to this rule. If a railroad company furnishes for white ladies a car with special privileges of seclusion and other comforts, the same must be substantially furnished for colored women. All travelers have to submit to some comfort and inconvenience and should not be too exacting. The brakeman on the train, having referred Mrs. Longwood to the conductor, who was the proper officer to decide upon her right to ride in the ladies' car, and she having gone to him, the question of the case must be determined by what occurred between them and if you believe from the proof that the conductor ratified the act of the brakeman by telling her she must ride in the front car and would not be permitted to ride in the ladies' car, the company is undoubtedly liable for damages, unless you conclude from the evidence that the front car was, under the rules already announced, equal to the ladies' car. But if you believe that the conductor told her that, at his convenience, he would admit her to the ladies' car, and there was no unreasonable delay or discomfort in so doing, the plaintiff cannot recover in this case. In the case entitled Murphy versus Western and Atlantic Railroad and others, the Circuit Court of Tennessee held that a railroad company may set apart certain cars to be occupied by white people and certain cars to be occupied by colored people, but if it charges the same fare to each race, it must furnish substantially like and equal accommodations. It was held in Maryland in an admiralty proceeding that a steamboat plying on the Chesapeake Bay, the colored female passengers may be assigned to a different sleeping cabin from white female passengers. The right to make such separation can only be upheld when the carrier in good faith furnishes accommodations equal in quality and convenience to both alike. In the year 1888, the legislature of the state of Mississippi passed an act of which the act under consideration is identical. In a case reported in 133 United States Report at page 591, the Supreme Court, in interpreting the Mississippi statute, used the following language. So far as the first section is concerned, and it is with that alone we have to do, its provisions are fully complied with when to trains within the state is attached a separate car for colored passengers. This may cause an extra expense to the railway company, but not more so the state statutes requiring certain accommodations at depots, compelling trains to stop at crossings of other railroads, and a multitude of other matters confessedly within the power of the state. The argument herein by counsel of the defendant is displayed great research, learning, and ability. The court, however, is of the opinion, after mature deliberation and a careful consideration of questions involved, of the authorities cited in support of the grounds presented, and the able argument of the district attorney for the reasons stated, that the plea herein filed by defendant should be dismissed, and it is further ordered that defendant plead over.
I'm a reporter with the Crusader. As was expected, Judge Ferguson of the criminal court overruled the plea to the unconstitutionality of the separate car law in the well-known Plessy case on a motion to quash information. We have no favors to ask of the judge or of the assistant district attorney, and consequently we will exhaust all remedies which the laws of our country allow to its citizens for a redress of grievances. This of itself is a great stride out of oppression. Everyone knows that notwithstanding the Constitution and statutory enactments, due process of law is absolutely denied to men of the black and mixed races in many parts of the United States, notably the South.
And I'm a reporter from the Times-Democrat. We are glad to see that Judge Ferguson has decided the Separate Car Act constitutional and thus put a quietus to the efforts of some Negro agitators to disobey it and sweep it aside. The Times-Democrat earnestly urged the legislature to pass that act at the same time it first came up and congratulated the people of the state on its passage. Indeed, we should have liked even more far-reaching legislation that would tend to separate the two races in the South thoroughly. The law, however, was a move in the right direction, framed in the interest of the traveling public, and intended to show the Negroes that while they live side by side with the whites, the line of distinction and separation between the races was to be forever kept up.
On November 22, 1892, Plessy and the Comité des Citoyens appealed Judge Ferguson's ruling to the Louisiana Supreme Court. The court swiftly upheld Ferguson's ruling. The Comité then appealed the Louisiana Supreme Court's decision to the United States Supreme Court, with the hopes that the highest court in the land would rule in their favor and settle the question for the entire nation. However, they would not know the tragedy that lay in their path.
We'll now proceed with the CLE panel.
Yes, we will now proceed with the panel. If our panelists would please take their seats, and we are going to discuss what just happened and discuss developments in the past 125 years. That's all, just 125.
Let me start with you, Judge Reeves. Why do we celebrate Plessy v. Ferguson?
Well, it's a milestone event in the history of this country because in the decision rendered in 1896, it codified the doctrine of separate and equal, which basically legitimated acts of discrimination and separation which lasted until 1954, approximately 60 years. And it delineated in all public accommodations, common carriers, pretty much every facet of life, particularly in the South, but throughout the United States, that was the law of the land. And until Brown versus Topeka Board of Education in 1954, when it was reversed in a 9-0 decision by that Supreme Court, it was the law of this country.
We're fortunate enough to have the descendant of Homer Plessy here, Keith Plessy. Keith, from your perspective, the significance of what your forefather accomplished?
Well, in terms of his case, it is on record as a loss in U.S. Supreme Court, the Plessy v. Ferguson case, which eventually came out of this case. But it set a precedent for a battle that would continue for those 60 years, and it inspired movements such as the Niagara Movement and the NAACP.
We're likewise fortunate to have the descendants of Judge Ferguson here. From your perspective,
well, from my perspective, that was just a little bit too painful. I guess it's not easy being born on the wrong side of history. You know, I have a lot of questions for my great-great-grandfather. Unfortunately, he's not here to ask him. Unfortunately, we also do not have any diaries or any personal notes from him. But I might say that it was difficult to read to listen to his ruling and how he based his decisions. But it just might be interesting for the audience to know that Judge Ferguson was not from Louisiana. He was from the East Coast. He was actually born in Martha's Vineyard, and he studied law in Boston. And he studied law under a lawyer who was also an attorney general, but he was also an abolitionist. And he was there during the Civil War, and he did not join the Union Army. He just studied law. That's all he cared about. And then he came down here in 1865, basically as a carpetbagger, and hung out his shingle, and very quickly married into D.J. Earhart's family, who was a very outspoken abolitionist in New Orleans. So he had, would like to be a fly on that wall, right? But over the next 30 years, he had latched on to the coattails of Murphy Foster, and then Governor Murphy Foster, and Nichols, and eventually he ended up being appointed to the Supreme Court, to the District Court for this, just after this, Homer Plessy was arrested. So, I struggle to understand his ruling because I think he ultimately was a man of the law and believed in the Constitution, as he did deny the first test case, where the train traveled outside of the state of Louisiana. He threw that case out. So, you know, not much else to say there.
Any comments? All right, Judge Tobias. Without character for you to play the role of Judge Ferguson, but nonetheless, from your perspective.
It's interesting to, I look at it after 30 years on the bench, over 30 years on the bench. One of the things that I have learned is that it is very difficult being a judge, because at times you are asked or required to enforce laws with which you personally disagree. A few years back, the United States Supreme Court held that a candidate for judicial office can state his or her views on controversial issues that may come before the court. And that is proper campaign procedure. You're allowed to say, for example, that if I, as a judge, if you elect me as a judge, you will, I promise to decide every case involving abortion to ensure that the child is not, that the mother does not abort the child. And you can make that pledge and you can get elected on that platform, so to speak. Not that I would ever advocate someone do such thing. And you can have a case involving abortion. And the reality is, if the lawyers do not put on the evidence to allow you to reach the decision that you feel you must adhere to, then you as a judge cannot rule that way. And unfortunately, too many people, in my opinion, and I think the press too, expect judges to act as purely political animals and rule exactly as they, that the populace that elects them, or that the populace wants them to rule. And unfortunately, it's not that way. The one thing I learned as a judge in 30 years is that every time a judge rules, myself included, I make one person unhappy and one person ungrateful. And it is, I don't think we give our judges enough credit for doing that. What Judge Ferguson did, I think he was under, he probably felt the political pressures. If you read the newspaper account that they were supporting, you know, as the saying goes, never get into an argument with any publication that buys ink by the barrel. I wish Donald Trump would learn that, but he hasn't yet. That type of, that he may have felt some pressure in that regard, I have no idea. It's a very frustrating situation to be a judge and to rule how you are expected. The case of Plessy versus Ferguson was well known. The result was pretty much known, how it was going to come out. I think you could argue that since he was not going to be the final arbiter of the issue, he could rule and just say, okay, I'm going to adhere to the laws of the state of Louisiana, which elected me, appointed me, and for which I am obligated to follow, and leave it to the other courts, the higher courts, the Louisiana Supreme Court, the United States Supreme Court, to say that he was wrong. I personally have been in certain types of situations like that. In certain situations, for example, one issue that I have been, that not related to this, but just to, I'm going to wrap it up very quickly. One of the issues that I have always been bothered by is eyewitness identification.
lawyers over the last 20 years or so, roughly 15, 20 years, have tried to call expert witnesses to testify about the unreliability of eyewitness identification. And the Louisiana Supreme Court has consistently knocked down that right and said you cannot call an expert witness to testify on the subject of eyewitness identification. A defendant is not allowed to do so. That bothers me, especially since I have always found it difficult to remember faces and names and so forth. And in the heat of the moment, to be able to, when something is happening, to be able to identify someone. And I think a lot of us do that. But the Louisiana, and I've had to enforce that. About 3 years ago, I once again wrote an opinion upholding this Louisiana Supreme Court decision, following their jurisprudence, but I firmly disagree with it. And of course, my opinion in support of affirming pointed out the shortcomings of the earlier jurisprudence. So I think people need to recognize that, and whatever Judge Ferguson did, I think he felt he was obligated to do so under the laws of Louisiana. Not that I necessarily agree, but if you can't agree, if you cannot uphold the law as it is interpreted or expressed or written, then you shouldn't have the job. And that's just generally how I feel about it. It's not an easy job.
Greg, you are traditionally on the side of truth, justice, and the American plaintiff's way, and yet we're drafted to play the part of the evil state's attorney in this reenactment.
Yeah,
I
thought I was getting your part when you asked me to do this, and then I found out afterwards that I was not going to be doing that. But you know, being a child born in '55 and knowing nothing else other than Brown versus Board of Education, that was the norm as I grew up. Thinking back and looking back and knowing that the argument that I did for Lionel Adams, that this was actually word for word everything he said, and that back then that was the default. That was what was considered normal, as backwards as it seems to us now. And you just marvel at how history unfolds and how time, fortunately in this case, changes everything. But I thank everyone for giving me the opportunity to do this, as dastardly as a part as this one.
Judge Reese is a legal historian on the panel. I know that you give a special significance to the dissent of Justice Harlan of the United States Supreme Court in this decision. Would you share with us?
It would be my pleasure. John Marshall Harlan has always been a legal hero of mine. And you know, we all heard about Brown versus Topeka Board of Education, which overruled Plessy. But as I came to know Plessy and understand what the case stood for, and if you're going to look at history, I was very fortunate when I was at St. Augustine High School, plug, to have a priest, Father Wilbur Atwood, who taught us to look at history as a snapshot of the time. And you have to see what the attitudes, what the prevalent conditions were, what the norms were, to get insight into what people were doing, how they thought, and how they reacted. And their actions became the history. In 1890 in New Orleans, well, let's go back to 1876, the Hayes-Tilden Compromise, where Rutherford B. Hayes became the President of the United States. A deal was made because that election was thrown into Congress. And Rutherford B. Hayes agreed with the Southern congressional members that he would withdraw the federal troops from the South if they would vote for him to be president. And the Union troops were withdrawn, and with that, Reconstruction ended. And then the dismantling of all of the civil rights legislation and the 13th, 14th, and 15th Amendment and all the freedoms that it brought to the slaves started to be dialed back. So by 1890, you're starting to see the beginnings of the Jim Crow legislation coming into full force and effect. The Separate Car Act was part and parcel of that. Now, in New Orleans, the committee the Comité des Citoyens was a group of people of color, primarily, who said we have to do something about this to try to fight this turnover of what freedoms we had during Reconstruction. I mean, in Louisiana at that point, you even had, an African-American governor, PBS Pinchback. He wasn't governor for long, but he was. And they had seen all that within their lifetimes and said, we cannot let this escape. So they challenged the Separate Car Act by Homer Plessy agreeing to get on the car and allow himself to be arrested. The case got to the U.S. Supreme Court in 1896. And in an 8-to-1 decision, embodied the concept of separate but equal for the next 60 years. But there was one voice on that court, John Marshall Harlan. And I did a little bit of research into him, and he was a very interesting individual. He was from Kentucky. He was born, I think, 1833. He went to college and finished college at age 17. He became a lawyer. His father was a lawyer. He apprenticed with his father, became a lawyer at age 20. When the Civil War occurred, he joined the Union Army. He did not want Kentucky to secede from the Union. He joined the Union Army and became a colonel. After the war, he became interested in politics. He ran for governor of Kentucky 2 times in 1871 and 1875. In 1876, he became a Republican. Well, he became a Republican before that. He went to a Republican convention, and he helped nominate Rutherford B. Hayes. And after Hayes won the presidency, he appointed him to the Supreme Court. Now, John Marshall Harlan, even though he was a Southerner, he was very progressive and probably was an abolitionist. But his dissent, and I strongly urge you, if you get a chance, to read the entire opinion, because his comments were prescient about what was going to occur in the United States when, because of the decision that was rendered by the majority of the court. I'd like to read you a few excerpts from it, if I may.
Absolutely.
In the view of the Constitution, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or of his color when his civil rights are guaranteed by the supreme law of the land are involved. This arbitrary separation of citizens on the basis of race, while they are on a public highway as a badge of servitude, wholly inconsistent with the civil freedom and the equality before the law established by the Constitution. It cannot be justified on any legal grounds. If evils will result from the commingling of the two races upon public highways established for the benefit of all, they will infinitely less than those that will be surely come from state legislation regulating the enjoyment of civil rights upon the basis of race. We boast the freedom enjoyed by our people above all other peoples, but it is difficult to reconcile that boast with the state of the law which practically puts the brand of servitude and degradation upon a large class of our fellow citizens, our equals before the law. This thin disguise of equal accommodation for passengers and railroad coaches will not mislead anyone, nor atone for the wrong done this day. And he concluded, race guides in the era introduced by the recent amendments of the Supreme Law was established universal freedom, gave citizenship to all born or naturalized in the United States and residing here, and obliterated the race line from our system of governments, national and state, and placed our free institutions upon the broad and sure foundation of the equality of all men before the law. For the reasons herein stated, I am constrained to withhold my assent from the opinion and judgment of the majority. Now for him, at that point in time, as a Southerner from Kentucky, to go against what the pervading attitude was towards race in the country at that time was nothing short of heroic, because he ostracized himself from the members of his community, probably from society in Washington, from the members of his court, etc. But Judge Tobias, that is what a judge really has to do sometimes. You have to go against the grain. You have to take a stand. You have to do what the law calls upon you to do, and you have to have the courage to stand in the face of the opposition. If you're not willing to do that, I agree with you, you shouldn't have the job. So.
It's a rare occasion that we have descendants of such historical figures here, as well as legal scholars and champions of civil rights. We wanted to save the last 5-10 minutes for any questions any audience members may have. Yes, sir. Let's get the mic.
I'm going to go around the other side so people don't have my back. A number of years ago, at a conference in New Orleans, Phoebe Ferguson came to speak, and she met Keith Plessy. And they decided to form Plessy and Ferguson. And as a young man who grew up in New Orleans, I'm A.P. Turo Jr., who worked with the NAACP lawyers throughout the country to defeat the decision of Ferguson and the Supreme Court decision. I spent all of my growing up years here in New Orleans being segregated, being told that I could not go here or there, but I had the opportunity to live with, to travel with, to pick up Thurgood Marshall and his crew of legal eagles, and to hear people all over this country talk about things that needed to be changed and how we needed to have leadership in the courts to bring justice to America. Constance Baker Motley was one of Thurgood Marshall's outstanding women lawyers. She was from one of the Caribbean islands. She argued before the Supreme Court, I think, 7 or 8 times and won just about all of her cases. I remember picking her up at the airport one time. She was here to work on a case that was coming through the Fifth Circuit Court of Appeals, because the lawyers would come from Thurgood's office to deal with the cases that were on appeal here in the Fifth Circuit. And she was saying to me about, I think it was, it might have been the, I don't want to say it was the James Meredith's case in Mississippi, because that probably didn't go that way. But she was telling me how difficult it was for black lawyers to be before judges and to go into courtrooms where she said the judges were the most hostile persons in the courtroom towards them as black lawyers. My father and the lawyers that came out of Howard University in the 20s and 30s were told not to use their first names if they want to practice law in the South, because they would be called by their first names or worse. My father was never known by his family as A.P. Turo. He was known by his name, Alex. But he chose A.P. Turo because Charles Hamilton Houston said, don't do it, because they're going to call you boy or ape or Alex or whatever. So the whole idea of courts, what they do, what they don't do, how justices can stand up for what is right, how populations, cities, and states can ride on unjust laws for generations. We're dealing with a situation today, in my opinion, I'm not a lawyer, but I feel that we need to litigate so many of the things that are being reduced now, and so many of our civil and human rights that are being diminished. And we have judges, we have all kinds of lawyers, we have many women who are in the legal system. We need to relitigate, we need to stop gerrymandering, and we need to bring back a healthy, robust attitudes towards human rights for everyone. And it's a pleasure to be in this courtroom. It's a pleasure to have Plessy explain to us, to be acted out, and to say, this is where we were, but this is not where we are. And we need to make sure that we don't stay where we are, because where we are right now needs to be improved and needs to be moved forward.
All right, any questions from the audience? Yes, ma'am, in the back row.
Take a stab at it. Plessy versus Ferguson and Brown versus Board of Education, which overruled it, dealt with overt racism in public accommodations and various segments of our society. But we still have a problem with racism in this country. And it has become virulent again. It has become ugly again. And we have a problem discussing it. I've been fortunate to go to South Africa a couple of times. And what really astounded me was that there, as ugly as apartheid was, and as harsh as the feelings that it generated were, the attitude of the Africans and the Afrikaans about race is they just go at it. If they have a problem, they say, we're going to deal with it. Nelson Mandela had the foresight to establish reconciliation commissions, and the purpose of them was to openly and honestly, and sometimes even painfully, deal with the issue of race. And we've never done that in this country. And until we do, we will never, never progress to be the country what America really can be.
Yes, ma'am.
Do you realize that the economic disparity in South Africa is worse than it's ever been? So
yeah, but everybody can vote. Everybody can, and Jacob Zuma is not my favorite person, let me tell you. I don't. No. Yeah, but I'm talking about the attitude and the discussion. Well, everything is not money. There's the human spirit that has to be accounted for.
Yes, sir.
Judge Reese, to your point, and to the point this lady made, nobody ever talks about the conductor, because the conductor was empowered with the authority to throw Mr. Plessy off the train. The same thing is happening today with the Trump movement. It's not so much the, I guess, the powers that be. It's those people that are losing their sense of entitlement and power that are pushing this current, I guess, attitude that we have in this country right now about race, immigration, and every other thing. So I just want to thank y'all for listening.
Okay.
Comments relative to that? Yes.
I actually had a question. Well, two questions. Was Judge Ferguson the author of the phrase separate but equal?
No.
And what can you tell us about Messrs. Walker and Adams and their careers? They ultimately argued the case for the Supreme Court.
I don't know the answer to that.
Nor do I.
Okay, that's your assignment, Mr. Berry.
I don't believe Judge Ferguson was the author of Separate but Equal. I do remember I don't believe that Judge Ferguson was the author of the phrase separate but equal. I recently did read that. I just can't remember what.
I just wanted to ask you if you think that maybe fairness and doing the right thing is passed down through the DNA, because Judge Harlan's grandson was the Supreme Court Justice with Muhammad Ali.
Well, I sincerely hope that at the dinner table or Thanksgiving table or something like that, there was a discussion. And actually, John Marshall Harlan was named by his father after Justice John Marshall. So perhaps he took that as a charge from his father to be fair and equitable on the court. Hopefully so, because and actually, that wasn't the only progressive decision that he made. He had a case with, I think it's called Hawaii versus Kanachi, if I remember correctly. And in that particular case, he voted to give the same rights to the Hawaiians when Hawaii came in 1903, that every other citizen on the mainland should have under the Constitution. He was pretty progressive and he was pretty productive. So potentially, that should have been the case.
Judge Tobias, you mentioned that the lawyers, the judges are confined to what is presented to them by the lawyers as evidence. How does that domain overlap with what is law according to the legislature, whether it's discussed or not or presented? And then when you get to the Supreme Court, I presume they can sort of, create a new path? Is that, I mean, are they stuck with the
Subjected.
what the legislators voted?
No.
I'm not a lawyer, so these are.
Be thankful. I have pondered this issue many, many times, and I was a trial court judge for 14 plus years. I was a Court of Appeal judge in this building for 16 plus years. And I retired in December of last year at the age of 69. I could have run for another term. And I have, one of the things that came across my mind as a judge is on an intermediate appellate court. And I alluded to the case of the issue of expert witness and identification. I had come to the conclusion personally, on other reasons, but that kind of inability to recognize that science is developed to such an extent that it was a small part of it, but it tells me that, that's their decision. I, as a trial judge or as a Court of Appeal judge, I can criticize or I can question and point out things, but I'm still obligated to follow. And if you don't do that, you are subject to being removed from the bench by the Judiciary Commission. I mean, it's not likely to happen, but it could happen. And so you're placed in the position of having to balance that. I have, in my lifetime, have stood up for the. In 1992, I put forth and convinced the Louisiana Supreme Court to create the Louisiana Task Force on Racial and Ethnic Fairness in the Courts, because it's something that I really believe in. As a result of doing that, I was basically ostracized by the judges in this state, by the Supreme Court and so forth, that isn't what they wanted to hear. And so I've been a sort of in a certain way, a persona non grata because I stood up for that. I do not regret it in the least. I can go back into my own personal history. I was a child, and the person who used to pick me up from school, I went to Newman School, uptown, and I was probably about 9 years old, 8 or 9 years old, and the person who normally picked me up to take me home couldn't pick me up, and I had to get on the streetcar that week, for a week, an entire week. And I remember I got on the streetcar, and I didn't know anything about the movable signs that they had on the streetcars. Some of you may be old enough to remember them. And I remember just sitting down, and it turned out I sat behind one of the signs. And I remember this Caucasian woman getting on the streetcar, and the streetcar was pretty filled, and she walked up and she looked at me and saw the sign in front, and she looked at me very carefully, and she picked up the sign and put it on the seat behind me. on the seat I was seated at, and then she sat down next to me. And I pondered that. And then later that week, I remember getting on the streetcar, and this African-American man who was apparently coming home from work or something, and the body odor was noticeable. And I thought about that, and whatever, and he didn't sit next to me, he sat behind me, but you could still smell the body odor. And the thing I pondered when that he had as much right as I did to be on that streetcar, and it didn't make any sense that that sign was there or anything else. And those two incidents that occurred in that 1 week, riding a streetcar where the fare was 7 cents, it's a little higher than that now for streetcars, I think.
Yeah.
Those two things were sort of in my own life that pointed out to me that you got to do what's right and see that people are just people. And that's been a guiding light of my life, and I don't regret for 1 minute that I stood up to say that to deal with the rights of people, of all people, to fair and impartial treatment in the courts. And I would do it again in a New York second, or maybe I should say a Louisiana second. It's a little slower down here. But that's how I feel, and you're welcome to disagree with me.
Ladies and gentlemen, we're out of time, but the panelists will be available to answer the additional questions at the reception to follow. This presentation and the ability to do it in this courtroom is solely as a result of the largesse of Her Honor Chief Justice Bernard Johnson, Dr. Johnson, and the other associate justices of the Louisiana Supreme Court. Please join me in thanking the court for its hospitality. In addition, this presentation was a lot of work by a lot of folks. Angela White-Bazile, I don't know if Angela is here, executive counsel to the chief, worked tirelessly with Miriam and Phoebe and others in putting this presentation together. The Supreme Court of Louisiana's Historical Society, the A.P. Turo American Inn of Court, started by Her Honor Justice Johnson and continuing here as the best Inn of Court locally, if I must say so. The New Orleans Bar Association, the Louisiana State Bar Association, the Law Library of Louisiana, and the Louis A. Martinet Society, all sponsors of today's event. Please join me in thanking those fine organizations for their downstairs on the first floor. Caterers is all set up, and please join us for the reception to follow. Thank you for attending this evening.
All right.